Hello, everybody. Thank you so much for joining us today. My name is Juan Carlos Brando, and for me, it's always a pleasure to be here with you and to share this information with everyone that is joining us today in this live show with one of the attorneys in the law firm of Margaret W. Wong and Associates. As usual, when we have the chance to talk about immigration with the attorney Francis Fung Sang, for me, it's an honor and it's um, very what is the word? Uh, it's very rewarding, I would say, to talk to him because I get to learn a lot about immigration. So if you have any questions today, just please feel free to ask your questions. Feel free to send your questions through our Facebook Live today or through our YouTube Live, and I'm sure the attorney Francis is going to have an answer for you in any immigration case. So thank you so much one more time for joining us today, and let's welcome the attorney Francis Fonsang. Good afternoon, attorney Francis. How are you doing today?
I'm good, thanks. How are you?
I am doing good. Just a little bit of uncertainty about what's going to happen next year with so many people that have been paroled, either through a petition or from the border. Let's say about the border, we know what's going to happen in many cases, but what's going to happen with the people that came on a humanitarian parole and that parole is expiring? Is Donald Trump going to be able to remove that parole and cancel that parole?
Well, I mean, these parole programs were for humanitarian reasons, and they were always meant to be temporary in nature. Okay. Number one, to stop people from trying to cross the border illegally and becoming a security issue. And number two, if they had an approved petition, they could come to the United States on the parole to wait for that petition to apply for the green card here. Now, those paroles are only valid for 1 year, 2 years at a time. So if they wanted to stay here, they would have had to extend or re-parole anyways. Now, we don't know what the new president is going to do once he comes into office in January, but he's talked about canceling a lot of these immigration programs, talking about increasing deportations. So we can't be sure what's going to happen. But if we cannot extend those paroles, then we'll have to figure out what else we can do to keep these people here.
Okay, and well, that's one of the things that we need to keep in mind. Would it be recommended for people that came on a parole to file for asylum if they have a case?
Okay, so in general, applying for asylum, there's a 1 year rule. You're supposed to apply for asylum within 1 year of coming to the United States, but there's an exception where if you have lawful status or there's a change in your circumstance, then you're allowed to file later. So if you're legally here on a parole and you're approaching that 1 year and you have an asylum claim, we would recommend that you apply for asylum within that 1 year so you don't have to worry about that deadline. But if you do have parole and it's valid, then I think you can still file for asylum beyond the 1 year and say that this parole allows me to stay here and to work, and it should be an exception to that 1 year rule.
Okay, thank you very much, Attorney Francis. And well, let's start with the first question that we are having today. And this question says, what happens when the Board of Immigration Appeals briefing schedule has expired and no DHS brief was received? Thank you.
Well, I mean, technically, if you're ordered to be deported by an immigration judge, the judge denies your case. You have 30 days to appeal to the higher court, which is the Board of Immigration Appeals. Now, you can appeal your case, or if you win, the government, Homeland Security, can appeal the case. Okay. After the Board of Immigration Appeals receives the file, eventually they will issue what's called the briefing schedule, where each side makes their legal arguments. They will submit a brief to explain their legal arguments. And if you don't submit your brief on time, you can try to submit it late, but the BIA could say, well, it's too late, we're not going to accept it. That means that they might still consider whether to process the appeal, or they might rule in your favor because the government is not arguing against it. Okay? But there's nothing you have to do right now, because that was the government's responsibility to submit their brief.
Okay, so well, if you need more advice about this case and need to know what to do in order to ask immigration or the DHS to send the information or the brief to the Board of Immigration Appeals, if you need help with that, just give us a call. The phone number is 216-279-3984, 216-279-3984. Next question is, hi, I've been married for 3 years. I have a baby. My husband petitioned for me, and I got my conditional green card for 2 years. It is expiring March 25. He wants to divorce as soon as possible, and my concern is what's going to happen with my green card. I need to renew it. He cheated and now wants to leave me and our daughter. He does not want to wait for me to file for the renewal.
Okay. Well, first of all, I'm sorry this happened to you. This is not your fault at all. The good news is you can still get your permanent 10-year green card approved. Okay. So after you get the 2-year green card, in the 90 days before the green card expires, that means December 25th to March 25th, you have to file an I-751 petition to convert the 2-year conditional card to the permanent 10-year card. Now, if you two are still legally married, then it's supposed to be what's called a joint petition. You and your husband sign the form 751 and file it together with documents to show that it's a real marriage and you are still together. Now, what happens if the two of you are separated or your spouse is not willing to sign? Well, you still have to file a petition before the expiration of the 2-year card. But if he's not willing to sign, then you're supposed to check off one of the other boxes on the form. That means either you two are legally divorced, but it's still a real marriage. You were abused, either emotionally or physically, and that's why you're filing on your own. Your spouse passed away, so he can no longer sign. Or you would experience hardship if you had to leave the United States. Now, in this scenario, typically we would check off the box where you are divorced, even though you two are not legally divorced yet, because you have to check off one of these boxes and eventually you'll get divorced. At some point, the Immigration Service will issue what's called a request for evidence to ask for the divorce decree because you don't have it yet. So eventually you'll need to submit it to immigration. So if he files for divorce, then that works because you can still get the green card. You can file divorce because he's cheated. And then you can show the divorce decree. And because you two have a child together, there should not be a question of whether it's a real relationship, a real marriage. That's the best evidence of the relationship. So what I would recommend now, start gathering any documentation you have to show that you two have been living together and it's a real marriage. That means taxes you filed together, bank statements for your joint bank accounts, if you had car insurance together, if you had any benefits together, a credit card together, any pictures of the relationship. Keep all of those documents now because it'll be much harder to get it if you two are going through divorce or are separated.
Thank you very much, Attorney Francis. Very clear the answer to this person. So if you need advice or need help with this case, just call the phone number 216-279-3984, 216-279-3984. The next question is, I have U visa BFD, bona fide work authorization. Do we consider illegal?
Okay, so when you file a U visa, that's a petition that's filed if you are a victim of certain crimes. Okay. Now, because you have the U visa petition pending, I would not consider that to be illegal. You should not be deported by immigration if you have that petition pending. Okay. The Immigration Service will usually respect that you are a victim of a crime and give the Immigration Service time to process that case. Now, is that technically lawful status? No, because it's not visitor status or student status or a work visa status. Just having a work permit does not give you immigration status. That has to be approved, but you do have a pending application which allows you to stay.
Okay, thank you very much, Attorney Francis. Okay, the next question is very interesting. Hi, my brother was arrested 10 months ago. He got TPS granted but still detained. How can we get him out of jail? He was arrested due to a fight and then put on immigration hold, but now he got TPS approved. How can we get him out of jail?
Well, the first question is going to be, is he in police custody or is he in immigration custody? Because if he's in police custody, the question then is, was he found guilty or did he plead guilty to a crime and he has to serve a jail sentence? Or if he's not guilty or the case is still ongoing, can he get a bond to get released from police custody? Now, if he's in immigration custody, then the question is whether he's eligible for bond or not. But we have to figure out what happened to that fight. I mean, was it an assault case? Was he found guilty or not guilty? We have to find out what happened to the criminal case before we can figure out how to get him out of detention. Okay. TPS is lawful status. So usually if you have TPS approved, then the Immigration Service should release you. But the police, that's a different story.
Thank you so much, Attorney Francis. Don't forget that the offices of Margaret W. Wong and Associates have locations in 7 cities of the United States: Atlanta, Chicago, Cleveland, Columbus, New York, Nashville, and Raleigh, North Carolina. And the phone number is 216-279-3984, 216-279-3984. That's the phone number you need to call in order to talk to the attorneys in the law firm of Margaret W. Wong. Today, we're talking with one of the main attorneys in the law firm, Attorney Francis Fungsang. He is one of the experts in many areas of the immigration law firm. So if you have any questions, please just write it down and he will be answering you the question that you may have right now. So the next question we have is, hi, I am from South Africa. I came 6 months ago. Can I file for asylum?
Okay, so we talked about this before. If you want to apply for asylum, there's a deadline. There's a 1-year rule. You have to apply for asylum within 1 year of coming to the United States. So if you just came 6 months ago, then yes, you can apply because you're still within the 1 year. Then the next question is, do you have a claim for asylum? Do you have a good reason to apply? Are you afraid of being harmed or threatened if you go back to South Africa? Or has anything happened to you or to your family in the past which would cause you to be afraid to go back in the future? Okay. So the short answer is yes, you are on time. And if you have a valid claim, then you can apply for asylum.
Thank you so much, attorney. And yeah, it's very interesting. Asylum cases. Do you think asylum cases are going to be harder in the next government?
Well, yes, because you saw this in the first Trump administration from 2016 to 2020. The Attorney General published a lot of cases changing the law for asylum of who can qualify and who cannot. So family members who were hurt, or what is actually persecution that can qualify for asylum. they were saying that certain types of cases, even though you're harmed or threatened, does not qualify for asylum, which was not correct. Okay. Now, the Biden administration rolled back a lot of those bad decisions, but we can't be sure what's going to happen in the next 4 years. Are some of those decisions going to come back where there's going to be a lot more restrictions on who can qualify for asylum, what can qualify as persecution?
Okay, and we have another interesting question. This person says, I already applied for bona fide EAD almost 4 years ago, but still didn't hear anything back. What could be happening?
Okay, so if you apply for a U visa, that's you're victim of certain qualifying crimes, and you submit all of the necessary forms and supporting paperwork, the Immigration Service, it's taking 7, maybe 8 years for them to process these U visa cases. So the Immigration Service will actually do a quick review to see if there's a bona fide determination that you've done the necessary paperwork, and then they will allow you to apply for a work permit based on that bona fide determination. Now, if you already apply for the work permit with the U visa application, then once they make that determination, they'll just issue the work permit. But if you did not file the work permit application, then they'll send you a letter saying, we've made the bona fide determination. You can now apply for the work permit, and then you apply for the work permit. So the question is, did you get that letter, or did you already submit the work permit application at the very beginning? Because if there's no determination yet, and you file the work permit, then you're not actually eligible for it yet, okay? Now, if you did get the letter, and you did apply for the work permit, and it's been 4 years, then I would try to contact the Immigration Service to do an inquiry to see what's going on. Maybe it got lost in the shuffle, or maybe they're just very behind in the processing.
Okay, and this person states that is already a client of the law firm. So the easiest way to do this is, if you want to call the phone number 216-279-3984, 216-279-3984, talk to the person right there. They're going to find your case, and probably the case worker is going to give you all the information you need so that you can clarify the questions you have. So the phone number is 216-279-3984. Call anytime before 5 a.m. and they will give you an answer right away today, because they should have everything in the system for you. Thank you for this question. The next person is asking, I had a final order of removal in revision. I have a C18 work permit since. How can I get a status?
Okay, so I'm not sure what you mean by in revision, but if you have a final order of removal, that means you've been ordered removed by an immigration judge, then that means that technically the Immigration Service can use that to deport you at any time. So the question then is, how can we reopen that final order of removal so that we can get your case back into the immigration court system? So I would recommend you contact our office to get that more details about your case so that we can figure out how best to reopen your deportation case. Now, number one, you would need a copy of your immigration file. If you do not have the file, then you would want to get what's called a FOIA. That's a Freedom of Information Act request to get a copy of your file from the immigration court. Now, if you don't have that already, or you need some help, you can contact our office and we can help you get the FOIA from the court.
Yeah, so this person is asking because says that they have the work permit but need to renew it. They would do the work permit yearly, but now it's going to be for 5 years, but it's still going to be C18. So probably the question is, what proof do they need to renew the work permit?
Well, so the work permit's expiring soon, or it's expiring in 5 years?
No, it's expiring soon and need to renew it.
Okay, well, I believe C18 is based on what's called order of supervision, where if you have the final order and you're reporting to immigration on time regularly, you haven't missed any scheduled meetings, then you can keep applying for a work permit if you show that you have financial difficulty. Okay. So number one, you would need that paperwork to show that you've been meeting your order of supervision requirements, and you would have to submit the form, the necessary fee, and documentation, or at least a letter to show that you're in financial problems. You need to work in order to support yourself and your family.
Okay, thank you very much, Attorney Francis. Well, this person says, yeah, talk to who? The person on the question before sent already the client ID. Just call call the office, talk to the person in reception, and ask for your case worker. They will see all of that in the system, and they will forward your call to the person in charge of your case, and you will be able to talk to that person directly. So it's very easy. Don't worry about it. Just call the phone number 216-279-3984. This next question says, "Hi, attorney. I have a work permit based on asylum. I entered through the border in California, and now I got my work permit. I have been working for employer, and he says that he wants to help me if there is any work-based visa that he could give me. What would you suggest for me to do, or is this possible?"
Okay, so employers can sponsor workers for the green card. Okay, the process is called labor certification. Now, unfortunately, immigration is much stricter in approving the work-based green card. You have to show that you entered the United States lawfully and that you've been maintaining lawful status up until you submit the green card application. Okay, now there are some exceptions to that, but asylum, unfortunately, is not one of them. So depending on when you came into the United States, how you came into the United States, and when you apply for asylum, and did you have any kind of legal status between your entry and the asylum filing date, then you might have too much unlawful presence in order to qualify to get the green card through the employer. Okay? If you apply for asylum while you're waiting for that asylum case, you do not have any unlawful presence, but that is also not immigration status. It's not student status, visitor status, or even TPS. So eventually, you would have to leave the United States to apply for your green card through an interview at the US Embassy in your home country. But if you have too much unlawful presence in the United States and then you leave, you'll have what's called the 10-year bar. You can't come back for 10 years unless you get a waiver to forgive that bar. And the only way to forgive that waiver is if you have a spouse or a parent who is a US citizen or a green card holder who will have exceptional hardship. That means life is very tough for them if you had to leave the United States forever. So before you have the employer start this paperwork, I would recommend you speak with us to talk about your immigration history and the timing of all your paperwork to see if it's even worth it for the employer to start this case.
Okay, so basically, if this person came illegally, they are not allowed to file for a work-based visa like the perm, right?
Well, I mean, so if you came in illegally and then 3 months later you apply for asylum, then 3 months of unlawful status isn't necessarily going to be a problem for you if you go through the US Embassy in your home country to finish the green card paperwork. Okay, but if you came into the United States and then 9 months later you apply for asylum, 9 months would be too long because that would give you what's called a 3-year bar. You can't come back to the United States for 3 years. If you were illegally here for 1 year and then apply for asylum, that gives you a 10-year bar, so you can't leave the United States to finish the green card process. So it depends on how long you're here illegally before you apply for asylum.
Okay, thank you so much, Attorney Francis. We have another question, but before, just to remind, the phone number is 216-279-3984. 216-279-3984. Uh, I have an arrest case which was later dismissed and expunged. I forgot to request the court documents before the expungement. Will that affect my marriage green card case, which I am about to file?
Okay, so there's a difference between dismissed and expunged. Dismissed means that there's technically no more criminal case because it's dismissed, you're not guilty. Expunged means no matter whether you were found guilty or not guilty, the court has destroyed the file or sealed the file because they've decided that you qualify for that benefit. Okay. So if something has been expunged, it is still there for immigration purposes. Now, when you apply for a job and it's expunged, you don't have to mention it there. But if you're applying for the green card with immigration, you still have to mention expunged cases. It's still there. So I think what we have to do is, you forgot to request the court documents for the expungement. You can actually file a motion to unseal the records only for the purpose of making certified copies. You don't want to reopen the entire case. You're only unsealing the file to get certified copies of all of your records, and then they'll reseal the file. We can then review those records to see if it's a problem for your case. Because this dismissal, if you had to plead guilty before the case was dismissed, then it's still a conviction according to immigration. Now, if you did not have to plead guilty before the case was dismissed, then it is not a conviction, and then it is not a problem for your case, even if it's expunged. But I do recommend that you unseal the case just for the purpose of making copies of all the records. If you need help with this, contact our office, and then we can walk you through it.
Thank you so much, Attorney Francis. And don't forget, the phone number that you need to call to contact the attorneys is 216-279-3984. 216-279-3984. And I think we have time for one more question. And it says, should I renew my work permit on TPS now, which expires next year, or should I wait until I apply for re-registration on my TPS next year?
Okay, so technically when you have TPS, you don't renew the work permit. What happens is the Immigration Service will automatically extend the work permit according to the law. That means online, it will say, if your work permit expires on this date, it is automatically extended to this date. Now, they don't necessarily mail you a new work permit. You have to print out that law from the Immigration Service website to show it to the employer or the BMV as proof that you are actually allowed to work. Now, if you have to re-register for TPS, that means the program, the TPS program for your country is expiring, and the Immigration Service has redesignated that country. That means renewed that country for TPS. You do have to re-register. That means you submit a new application and a new work permit application to re-register. Then you'll get the new work permit based on that re-registration. So the answer is, you do not have to renew the work permit. Check the Immigration Service website for the TPS program for your country to check on that automatic work permit extension date, but then definitely re-register on time to make sure that you're allowed to get that new work permit.
Okay, thank you very much, Attorney Francis. And well, this person, I don't know if you want to answer to the question before, but this person clarified that there was no trial.
Okay, so that means if you were arrested and then maybe the judge said, okay, or the prosecutor said, okay, we're going to dismiss this case. So there's no trial, you were not guilty, there's no plea of guilty, there's no conviction, the case is dismissed, and then it is expunged. Now, technically on the green card application, there's a question that's asked, have you ever been arrested, cited, charged, or detained for any reason? Now, technically the answer would be yes, if you were actually arrested, that means handcuffs, taken to the police station. Even though that was later dismissed, there's no conviction. So it's definitely not a problem for you. But because you might have to check off the answer yes, I would still get those records. Even if you don't, it's not a problem for your case, the immigration will probably want to see those records. So definitely try to unseal just to get a copy of the records and then reseal the case.
Thank you very much, Attorney Francis. Our time is up for today. So thank you so much for answering all of the questions, and see you soon.
All right. Glad to have you.
Thank you so much. Have a good lunch, and see you next time.
All right.
Thank you. And for everybody who has joined us today, don't forget the phone number is 216-279-3984, 216-279-3984. Offices in 7 cities of the United States: Atlanta, Chicago, Cleveland, Columbus, New York, Nashville, and Raleigh, North Carolina. And the phone number is just one. It's 216-279-3984, 216-279-3984. Attorneys in the law firm of Margaret W. Wong and Associates. Thank you so much for joining us today. Have a good lunch and see you next time.